everybody, and welcome to Legal Studies Unit 4, Area of Study 2, the People, the Parliament and the Courts, Part 2. The focus of today's video is dot point 2, the roles of the Victorian courts and the High Court in lawmaking. The roles of the Victorian courts in lawmaking. What do courts hear? Victorian courts hear matters arising under Victorian law. Federal courts hear matters arising under Commonwealth law, and the High Court hears appeals from each state's Court of Appeal and matters arising under the Constitution. When can courts make laws? The judge's ability to make laws is limited. Law can only be created by a judge in a superior court of record when no precedent or existing legislation exists in relation to the case before them. This is called a test case. The judge is able and willing to expand on an existing precedent, or the judge is able and willing to undertake statutory interpretation. Test cases. Test cases, also known as novel cases, are cases in which the fact situation can be distinguished from the facts in previously decided cases and in which therefore no precedent applies. Courts must wait for test cases to come before time with a particular issue or legal question that has not been decided before a court of superior record in the same hierarchy. The court will be required to declare a new legal principle to resolve the case. Now looking at the role of the courts in lawmaking. The position of the court in the hierarchy may mean that it is not in a position to develop a new legal principle, that is precedent, which we will look at on the next slide. For a change in precedent to occur, the case presented before a higher court must concern a new fact situation to which no existing binding precedent or legislation applies. Even then, the court can only reach a decision in relation to the information presented in individual cases. It cannot change entire areas of law in the same way that Parliament can. The doctrine of precedent. The doctrine of precedent refers to the process by which judges follow the reasons for the decisions given by courts higher in the court hierarchy when deciding on similar cases. The doctrine of precedent is created by superior courts of record, and it creates consistency and predictability as people taking a case to court can gain some insight about the likely way the law will be applied. The principle of stare decisis. This principle is around the idea that judges should stand by previous decisions when appropriate to ensure consistency and predictability. The rules relating to stare decisis are: precedents can only be set by a higher court, usually when exercising an appellate jurisdiction. All lower courts are bound by the decisions of higher courts in the same hierarchy, and decisions of courts on the same level or from another court hierarchy are not binding. We will now look at the difference between binding precedent and persuasive precedent. Binding precedent is precedent that must be followed by courts lower in the same court hierarchy when dealing with the same legal principles and material facts. The ratio decidendi becomes binding precedent. If a precedent is binding on a case, it must be followed by the judge, even if they disagree with it. A precedent is binding when it was set by a superior court of record, higher in the same court hierarchy, or the case currently before the court is a like case of the case where the precedent was set, so meaning that the material facts of the case are similar. Persuasive precedent. Persuasive precedent is not binding, meaning that judges do not have to follow it. Under the principle of stare decisis, the judges may choose to follow persuasive precedent. Decisions that are considered to be persuasive include obiter dictum statements, ratio decidendi of courts on the same level or lower in the same hierarchy, or precedents set in courts in another court hierarchy. I'm going to give an example of both binding and persuasive precedent. So let's just say we have a matter in the Magistrates Court of Victoria that has similar material facts to a precedent established in the Supreme Court of Victoria. That precedent would be binding on the matter in the Magistrates Court of Victoria because it is higher in the same court hierarchy. On the other hand, looking at persuasive precedent, let's just say we have a matter in the County Court of Victoria that has similar material facts to a precedent established in the Supreme Court of Western Australia. That would merely be persuasive, that precedent, meaning that the judge in the County Court of Victoria wouldn't have to follow it. Even though the material facts of the case are similar, it would not have to be followed because it was set in another court hierarchy. Developing or avoiding precedent. If a judge is not bound by an existing precedent, they may decide to adopt the precedent, that is, follow or apply the precedent, even if they do not necessarily agree with it, affirm the precedent, meaning that they agree with it, or avoid following the precedent by either distinguishing, reversing, overruling, or disapproving of it. We are going to now look at the 4 ways that a judge can avoid following precedent. Sometimes these can be a little bit challenging to get your head around, so I will try and explain them slowly and in the best possible way I can, but I do encourage you to re-watch this and to do some reading in your textbook about the 4 ways that a judge can avoid following precedent. The first way a judge can avoid following precedent is by reversing a precedent. This can only occur when a case is heard on appeal. It occurs when the case that established the precedent is being heard on appeal. The ratio decidendi of the lower court is no longer valid, and the ratio decidendi of the higher court is the one to be followed in the future. The second way a judge can avoid following precedent is by overruling a precedent. So when a case comes before a court that relies on precedent that has been formed in an earlier and a different case in the lower court, the judge in the higher court may believe that the earlier case has been wrongly decided. The judge in the higher court can then choose not to follow the precedent set by the lower court. This is known as overruling the earlier decision. The new ratio decidendi, set by the higher court, will now become the precedent to be followed in the future. The earlier precedent, set by the lower court, will no longer apply. The third way a judge can avoid following precedent is by distinguishing a precedent. According to the principle of stare decisis, courts are only bound by precedent when dealing with like, or in other words, similar cases. If the judge can identify substantial differences between the material facts of the case where the precedent was set and the case currently before the court, they can avoid being bound by the existing precedent and potentially create new precedent. The fourth and final way that a judge can avoid following precedent is by disapproving of a precedent. Judges in lower courts are bound by the decisions of higher courts in like cases. Judges in lower courts may disagree with the ratio decidendi of higher courts, but according to the principles of stare decisis, must follow them anyway. Judges in lower courts can express their disapproval of an established precedent through their obiter dictum, given that they have no power to overrule or reverse a precedent. According to the principle of stare decisis, courts on the same level of the hierarchy are not bound by their own earlier decisions. When a judge does not follow an earlier decision of another judge at the same level, they are said to have disapproved of the decision, creating new precedent for the same set of material facts. Both precedents remain in operation until and unless a higher court sets a binding precedent to clarify the issue, or if Parliament either abrogates or codifies one or both of the precedents. There are many benefits of the doctrine of precedent, including that it creates consistency and predictability, as well as resources not being wasted arguing the same issues over and over again. However, there are some problems that are associated with the doctrine of precedent. We will explore 4 of these problems in this slide. The first problem is identifying relevant precedents. Finding relevant cases to support an argument from the volume of reported cases can be extremely difficult. Even when the relevant cases have been located, identifying the ratio decidendi can be a challenge. The judgment may contain many comments about the facts of the case, reference to other cases and statements about general propositions of law, as well as the reasons for the decision. It may in fact be difficult to distinguish between what is the obiter dictum and what is the ratio decidendi. The second problem is binding precedents. Courts are unable to make or change a precedent if they are bound by it. This can lead to an unjust outcome if an outdated precedent is applied to the case, especially if the affected party cannot appeal the outcome. This could be because of financial means or time restraints. Also, courts bound by precedent can express their disapproval over the dictum, which may encourage a party to appeal to a higher court where the precedent can be reviewed and potentially updated. The next problem is flexibility. Depending on the circumstances, courts may be able to avoid and develop existing precedent. Judges, however, may be reluctant to reverse or override an existing precedent. Although precedent set by judges on the same level is not binding, judges are often highly persuaded by this precedent for the sake of consistency and predictability. Judges cannot make laws whenever they like. They must be in a superior court of record, and they must wait for the relevant case to come before the court that presents them with an opportunity to do so. So this relies on parties being willing to take risks and pursue a matter in the courts. And the final problem we're going to look at is parliamentary sovereignty. Parliament can override precedent. This is, however, with the exception of High Court decisions on constitutional matters. This limits the ability of the courts to make and change laws. If Parliament makes a law to override a common law, the precedent made still applies to the case. The way the law is to be applied will change, however, for future cases. The roles of the High Court in lawmaking. Unlike other courts, the High Court is not bound by its own previous decisions. The High Court can overrule its own precedents if there are strong arguments and advantages to be gained from doing so. This helps to develop precedent and allows the final appellate court to reject and declare invalid any previous precedents, including its own that were once accepted as law. That concludes today's video. I hope that your knowledge of dot point 2 from Unit 4 Area of Study 2 has been consolidated. As always, if you do have any questions, feel free to leave them in the comments below or send me an email. Thank you.